Hi everyone, let's do a pivot here to individual rights. A couple more videos to go here, including this one. I'm going to go ahead and attach a series of templates that Professor Marin created. I worked on them a little bit as well, but they're mostly Professor Marin's work. They're going to be very helpful in terms of giving you a sense of what the exact verbiage you should be using. But I'm not going to read the templates to you. Instead, in this short video, I just want to make 5 brief points about what I've been calling your mental checklist, right? So as far as individual rights, let's start with the First Amendment. First Amendment issues should not be difficult to spot. There are, you'd have the government, some kind of government actor messing around with speech, obviously. When you see that, here are the 5 things I want you to remember. Then we'll talk about some sub-issues as well after I go through these 5. First, please remember the doctrine of selective incorporation. You need that for the First Amendment if the entity you're suing, if the governmental entity being sued is a state or a subdivision of a state. When that is the case, you have to remember that the First Amendment applies to the states and subdivisions of states through the Due Process Clause of the 14th Amendment. I've seen that in quite a few model answers, sample answers. So check that box, okay? If it's the federal government messing around with people's speech, you don't need selective incorporation. But in most of these questions, it's a state or a city, right, or some kind of subdivision of a state. So make sure you check that box, as I just said. Number 1, selective incorporation. Number 2, anytime you see a First Amendment speech question, look where the speech is happening. You know, in law school, we teach but don't necessarily emphasize to the nth degree this whole business of public forums. It is very common in these bar exam answers for you to see public forum analysis. At least, again, this is one of those things that, you know, where somebody checked the box, okay? So if you see that the speech was happening on a public sidewalk, public street, public park, outside of a public building, like a courthouse, things like that, you would at least, you know, get your points, your quick point or 2 for saying that's a traditionally open public forum, and the typical rules that you studied in common law apply in traditionally open public forums, TOPF. Now, other forums that are not traditionally open, like, for example, a state university, a theater, or a public school auditorium, things like that. Those don't have to be open for speech, but the government may designate those as open. So make sure you know when you see that. And the most common fact patterns would be state universities, public schools, allowing speech in a certain area, allowing the use of a facility for speech purposes. When the government does that, that's called a designated public forum, and the same rules then would apply there as well, which is you can have reasonable symbolic speech restrictions, conduct restrictions, if you will. You can have reasonable time, place, manner restrictions, et cetera, et cetera. A forum, once designated as open, can later be designated as closed, as long as it's done in a content-neutral way, where the government is not targeting the message. So, or the subject matter of the speech, really. That's what content neutral means. More on that in a minute. The only other kind of forum is a non-public forum. You know, public governmental office buildings, legislative chambers, residences that are run by the government, owned and run by the government, the White House being the most obvious example. These are not places that are intended for speech purposes, and speech purposes don't match up, right, with the functions that are being performed in those facilities, those buildings. So in a non-public forum, the government can impose any reasonable regulation as long as it does not discriminate on the basis of a viewpoint, right? So target people based on merely on their opinions. So again, please make sure that you're checking where the speech is happening. So again, mental checklist item number 1, make sure you check for incorporation, selective incorporation. Mental checklist item number 2, make sure you're looking at where the speech is happening, get your points for that. Number 3, you've got to check for whether the speech that's at issue, whether at least an argument to be made that it is unprotected or less protected speech. Unprotected speech, you look at your you have got to know your categories of that. There's incitement, where you're asking somebody to do something illegal imminently. There's fighting words, where you're in somebody's face, right, trying to cause an immediate breach of the peace. There's obscenity, so you need to know the Miller test. You wouldn't even get into that unless you have something of sexual nature going on. And then there's another category of unprotected speech that's coming into vogue. I've seen it in a couple of answers. It hasn't really been a big issue, but people have mentioned true threats, and this is especially an important issue, emerging issue, because of the things people say on the internet to each other, trying to cause each other to be in apprehension of great harm. So you might want to be aware of that. If somebody posts a threat and the recipient of the threat is reasonably in apprehension that the threat will be carried out, that may be regarded as unprotected speech as well. But the big ones are incitement, fighting words, and obscenity. So check for that. Now, when I say less protected speech, I'm talking about advertising, which is called commercial speech. Use the buzzwords, right? There was, I mentioned in a prior video, there was a fairly recent Florida bar exam question where the state of Florida banned citrus growers from out of state from advertising in Florida. That's a hybrid issue. There's two different issues there. One is dormant commerce, because it discriminates against out-of-staters. The other was commercial speech, because it's a ban on advertising. So for that kind of speech, advertising, remember your threshold questions. This is called the Central Hudson test. Your threshold questions are whether it's misleading, the advertising is misleading. If it's misleading, it's not protected at all. It's unprotected speech. If it is for an illegal product or service, then it's not protected at all. It's unprotected speech. So those are your threshold questions. Assuming that it's truthful and for a legal product or service, then it is protected, but it's less protected than other speech. And the way that works is, instead of strict scrutiny applying to a restriction on advertising, you would apply sort of an intermediate type of scrutiny, where you would check whether the means chosen by the government directly advance some kind of a substantial interest, so not compelling, but substantial, and are no more intrusive than or extensive than necessary. So to back up again, keep repeating, check for incorporation, right? If you got a state or subdivision of a state, make sure you check where and do your brief public forum analysis. Then make sure you're looking and going through your checklist of, is this unprotected speech? Is there some kind of argument that is not protected or it's less protected? Fourth, content neutrality. I've mentioned this already. I don't think, when I look at the questions that I've looked at on the model answers and sample answers, I do not think that I would leave a First Amendment question without using the words content neutral or content neutrality. Really, when you look at the whole body of First Amendment speech cases, and especially as regards two big issues, which are time, place, manner tests and the symbolic speech test under O'Brien. When a court finds that a governmental regulation or action of some kind is content-based, that triggers strict scrutiny. So, again, that content neutrality is such an important part of so much of First Amendment law that I would not, I would not leave a question without talking about it. It's almost sure that you would have to mention that and analyze whether the government's restriction, whatever it is in the fact pattern, is content neutral. Fifth, speaking of scrutiny, know your levels of scrutiny and apply them when you see one of these questions. Many of these fact patterns are designed to trigger strict scrutiny and make you apply strict scrutiny. So you have to decide whether the government's means were narrowly tailored to the achievement of a compelling interest. Even if, and as I said before, that is typically triggered by a content-based restriction, right? A restriction that is not content neutral. Even if a law is content neutral under time, place, manner, or under O'Brien, you still would apply a means ends test, but it's not quite strict scrutiny, right? It's a little bit easier. Under both of those tests, time, place, manner, O'Brien, you look for whether there is a significant or important interest, and you look for whether the means are more or less narrowly tailored. Courts don't really strictly apply that, but you would still use that language when you're looking at those tests. And I lied, just as I was speaking, I remembered something that I wanted to talk about that I forgot to put on the list. Don't make it 6. There are 6 things to put on your mental checklist. The 6th one is vagueness and overbreadth. Easy to talk about those ideas in almost any First Amendment question. You want to make sure that in its zeal to punish harmful speech, the government has not caught up other speech that is protected. That's especially important when you see an obscenity statute or something like that, where you want to make sure that the government's policy or law is sufficiently specific to give a person notice of what is allowed and what is not. That's critical in First Amendment cases. So let me review. In addition to the templates that you can see in the description below, right, by clicking that link, 6 items to put on your mental checklist when you see a speech problem. Number 1, selective incorporation. Number 2, where/public forum. Number 3, is the speech unprotected or less protected? Number 4, always check for content neutrality. That's a huge linchpin in these cases. Number 5, know your levels of scrutiny and certainly how to apply strict scrutiny. And finally, number 6, check for vagueness, overbreadth. Just merely using these words right when you're addressing one of these questions is likely to get you somewhere. Obviously, an artful application of these words is what you're shooting for. But as I've said a number of times in these videos, what we're trying to do here is make sure you're at least getting top-level issues. You know things to check for that so you won't miss it. Now, there are other sub-issues that can be tested. Lainey is here to try to help, as you've probably been able to hear throughout the video. Public school speech, where you need to know the Tinker test. Prior restraints, where you need to know there's a presumption. You can be tested on freedom of press. Right, access to courtrooms is one of the bright line rules. There are all kinds of little sub-issues that you want to be familiar with, but again, I hope this video helped you pinpoint 6 areas that have to go on your mental checklist that you would almost always look at in a First Amendment question. So again, hope that helps. We'll be posting one more. I know you all are getting close to the bar exam here, a few weeks away. Stay safe and look for another video shortly.